greetings, loved ones. Yeah, respecting X's question there and Wally's answer, not getting remedied in the legal system. Yeah, again, loved ones, as we've mentioned a number of times, it is a little bit harder said than... Wait a minute, no, that would be harder done than said. There you go. Anyway, this is where we're trying to get Bryce into a position where he's, getting his claim brought to the surface. And again, doing that as a defendant is virtually impossible. Doing it on the criminal side, clearly, is even more impossible. So what we're ultimately trying to do here with Bryce is get his civil claim in first. Believe it or not, criminal is a result of us messing up on the civil side. Once you protect yourself civilly on that civil side and do all the stuff we're talking about here, you're literally exempt from the legal system, the criminal side. That's why we got to be good boys and girls once we cross the line here, because we have, these superpowers where we can do things that normal public citizens can't do, again, which is why we're imploring there's a screening process going on here so that we actually have, hands on and we have minds on and hearts on with everybody so that we can kind of keep this direction as clean as we can. Point being, yeah, so Bryce, even though he hasn't responded yet, again, we've had other loved ones that they get thrown in jail for a day and then they're kicked out the back door. Another loved one here, a friend of ours, he rolled into court with his brother. When he started defending his brother in court, the judge got pissed off at both of them, found them both guilty for contempt of court, 30 days. Again, 2 minutes later, they're both ushered out the back door of the courthouse. So whoever was sitting on the public side in that courtroom thought that these two guys just got arrested, like for 30 days and thrown in jail. Yeah, no, not so much. So again, Bryce we're gonna get stuff tightened up with him. His petition, his claim on the civil side will defeat the entire criminal element here because it gets rid of the person. So he's trying to, we're trying to get it to the judge, shotgun, last minute, as still the defendant, and for the clerk to throw that one at us at the very end. Okay, yeah, we can deal with that. It's not a big deal. But again, this is why, loved ones, let's get on these things sooner, give ourselves a head start, than waiting for the last few days before you got to be in court or whatnot. I know where everyone's afraid to ask and everyone doesn't want to admit we need help here and there. But yeah, don't wait till hey, I'm going into court tomorrow morning. What should I do? That's a tough one. Give us all more time to work with all that kind of thing. Okay, and Big Kahuna has a question here respecting if he was born in one province but he's currently at or in another one, which particular legislative trustee acts specifically from which province would be best suited for what he's trying to do here. You know what? I actually, because, for example, mine, I stated that I'm here in such and such or near such and such a province right now, used some of that legislation because that would be local. That legislation could now be applied to another jurisdiction if need be, even if you were, or that other situation was in another province. Where, hey, the birth happened over here, and respecting the Trustee Act as it applies to the trustees in that neck of the woods, through some type of joinder, through some type of feasance of office, through some type of agreement, even granting the power to the trustees here to deal with the trustees there. Something as simple as that carries a lot of weight. Okay, so, or do these need to be cited for the province where, yeah, okay, so I think we got that one. To be honest with you, I guess a little further, realistically, if you were quoting strictly the birth province and then sent it back to the birth province and just suggesting that you're privately living or privately residing in a express inter vivos trust over here in, the unicorn land, that would actually work too. And then they could correspond with you and they could actually ask for more clarification, better instructions, which always seems to be the case here, where this is where they're so black and white, loved ones. There's no room for much error when you're dealing with land titles. It's a very specific scientific, technical language, and if there's a lot of fluff in there, it doesn't get through. So again, this is why, hey, Your Honor, hey, Magistrate, is there a simpler process? to affect our cause over here, judging by this affidavit and looking at the material evidence indicated in this affidavit, which leads into Big Kahuna's second part of his question there, where he starts to suggest, can a servant king and queen be jointly named in one affidavit? Yeah, and you know what, loved ones, at that point, as long as both parties are present, that's just a type of union. That's just another form of an agreement. That's an affidavit in trust, or affidavits in trust, made by the following parties, A and B, for the purposes of C. Yeah, that could all fly, absolutely. I think that was it for yours. I'm going to go back and do a little more checking. Hang on. And to further Big Kahuna's question there, again, servant king, even if he's in a different province now from the birth province, and his spouse and partner and her situation being similar, again, as long as we track these events down through an affidavit, this is the whole purpose of an affidavit. Today is such and such, and I did this. I created this affidavit that describes past events being such and such happened on this date, and then that happened on that date, and then so on. So you can literally, as long as you can track the events back, tell a bit of a story with it, throw in what the purposes were here and there, that little bit of color to the affidavit is absolutely going to support what the intent of the affidavit was. Maybe this is just an affidavit of notice, notice of life interest. Again, we can get so creative with these titles, it's a little bit silly. And as long as there's enough intent expressed, the judges and or magistrates will absolutely be able to help guide everything that it is we're trying to do here. So yeah, I've been waiting. Bryce is going to have some pretty cool stuff to say here. Hang on. So as X has indicated, so clarity is paramount. We need to actually state who is now vested in possession and who is vested in interest in our paperwork, question mark. For example, A is vested in possession, B is vested in interest. Example, to A for life and to B in fee simple. He goes on to say, so now we are for life, in brackets, in equity, and to vest the fee simple estate back to the crown. That's exactly what we're going to be doing. And we do all that wrapped up in a deed, duly sealed and duly executed. Get that thing notarized, and then go file that one at your local land county recorder's office or land titles for the Commonwealth system. Watch what happens now. The above is the actual nuts and bolts that the judges are looking for. They're looking for very specific language here. We can keep it simple as above. As X has indicated, it literally needs to be that long. You could almost count the words. It's ridiculously short. But this is why some of us that have been around the block a number of times, we've all encountered an experience where either lawyers or the Attorney General's office or the Registrar General or the judge themselves get back to us with, your paperwork is incomprehensible jargon. It doesn't make any sense. Well, this is part of the problem. We actually need to convey it as styled above. It's very precise. This is the requirements that land titles and the recording agencies have. It's not, that's just shit that's out of our control. But now that we're onto it, literally opening up this can of worms is going to be the last component that really truly starts to move that title. Now again, support the above, A to B for C, and and again, we're going to develop all this in the paperwork here in a number of days. So this is a hot topic that's coming down for us. When we support the above there with the special affidavits, and when we further support that with further adverse claims. Now again, I had noticed another loved one or three here just on this chat recently was suggesting, okay, so what's the difference between the adverse claim and the regular claims and things of this nature? The special thing about the adverse claim is that it is specifically concerned with a perfected interest in a financial asset. That's it. That's essentially what an adverse claim is. I mean, yeah, you can broaden it a little bit, but by definition, that's exactly what it's talking about. So now all we need to do is legally describe what that financial asset is, how it came to be, who did it, for what purposes, on what date, and for what intent, etc., etc. Once we nail all these completely important substantial problems that were now being solved, it's just a matter of getting this stuff all organized. and that will be discussed here in the next few days. Thank you, James Kenneth. He suggests, I use trusts and equity. I know David, and he does the same. I wish to merge titles and collapse trusts for the extinguishment of so-called debts. That's exactly what we're doing here, loved ones. Now, how does this merger happen? That's going to be another key component to what we're trying to do here. The merger is actually detailed, laid out, described in the deed. This is where party A, imagine a man or a woman. Party B, the person, the birth certificate that man or woman has in their back pocket. Those are two entities. So person A and person B, or individual A and person B, can literally be involved in a relationship, or I don't want to say a contract, but for the lack of a better term for now, it's an agreement between those two. Now, this is where we're suggesting party A, being a breathing, living man or woman, can literally vest an interest somewhere, and as soon as, or at the moment that happens, a return vest or something comes back in return. One is vested in possession, one is vested in interest. This is going to be the thing that extinguishes that old title, or that old construct, or that old house, or that old memorial, as a matter of fact. When you were deemed lost at sea, they created something for you to manage your estate while you were gone. Again, this is all stemming from feudal England days, 1,000 years ago, when knights would leave their village, their homesteads, their cities, and go fight. Okay, well, who's looking after all their stuff while they're off fighting? That's where this specialty contract / trust was created by the state, really, by the kings and queens. They thought that this was all a fantastic idea, and this actually does make a lot of sense. So now someone is managing your affairs while you're gone. Well, what happens, if unluck would have it and you wind up not returning home due to circumstances at war that were beyond your control? You never come back. Your state still continues. Your farm still continues. All that life energy still continues. So now we have a situation where if we never come back to say, hey, I'm back, I can release you of your duties, individual B or party B, so that I can now take control of my own affairs again. I have returned. This is a very important part of our deed. So this is all described there. This is all supported with an affidavit. This is, you've heard of other individuals and loved ones out there suggesting a live life claim. Or, hey, I'm back from being lost at sea and deemed dead. However you want to style that, as long as it gets the job done and a judge could basically understand what the hell it is you're trying to say, yes, include those. But again, so he's suggesting here that, we're going to collapse and extinguish debt through that old construct getting removed. Once that old title is removed, once that old situation is dealt with, a whole new trust exists. That old one gets to get flushed down the toilet. That's why there's an old trust. That's the implied trust. The new trust is the permanent one, the one a man and woman expresses because we've never done it. Since the day you were born, mom and dad did not do it for you, and we failed to do it. That's why we're deemed gone. The trusts is a modern day word for the word uses. There's something called the Statute of Uses that, again, goes back a few hundred years or whatever it is. That Statute of Uses is literally talking about trusts. I have the right to use something even though I don't own it. Well, how can that be? Well, if I set up a special agreement with the party that owns it, I'll enjoy the right of use. The right of use there, change that word use, make it synonymous with the word trust. So now I have the right through trust. You may have heard, I'm the beneficiary in use. Well, that just simply means I'm the beneficiary in trust. It's the same word. So get familiar with that one. We can do a lot of work with it. To round that out one, yeah, James Kenneth, thanks for the statement and the comment. Perfect. And continuing. And remember, loved ones, we want to be bringing our conflict to the attention of the judge. Your Honor, I have a conflict with the rules at law. It provides no adequate remedy, no complete redress, and it completely sucks balls. Therefore, I do not want to be a part of it, and I do not want to play in that arena. That's what's going to get you into the chancery or the equity side of the court. We have to plead that conflict. If you don't suggest you got a problem with the way things are, then they're just going to assume that everything's hunky-dory and they will steamroll you. Pleading the conflict is one of the most important things we have to do here, loved ones. Why is the conflict important? Again, back to the Judicature Act. Where there is a conflict or variance between the rules at law and the rules of equity over the same subject matter, the rules of equity shall prevail. Yeah, man, okay, so pull out your last name or a chunk of your name or just something to redact it slightly, although everybody knows who you are. Do something with your registration numbers on your birth certificate. Leave some of them, chop the other half, whatever. So we'll just make it so that if this documents, which they are going to do, once they start circulating, because someone on here is going to share it with their friend and share it with their friend, and we all know how that goes. So, again, just clean that paperwork up a little bit. But don't be blocking out entire sentences and entire words and shit like that, because as soon as people see black, they feel like there's something on there hiding that they're never going to get to see. And they instantly feel like they're looking at an incomplete something, and that's actually a very defeating type feeling. So I would rather, for my name, I'd rather black out DNA and let RREN still stand there, so you can basically fill in the blanks mentally, but I still didn't give it all to you, right? It's a way more satisfying system than letting people, feel or believe that we're still not trying to share as much as we can. Yeah.
Our last affidavit is a very good example, loved ones. You'll see how Kim went through and blocked out my name so that you could still see that it was just my name that we crossed off, and everything else was showing. So we're not leaving anything out.
And as a matter of fact, yeah, I would suggest let's start blocking half names. If you want to block your complete surname out, sure, whatever. But at least people can see what's truly hiding behind the curtain, and that they don't feel like they're not going to get those answers. Because I remember that feeling. I remember looking at documents 10 years ago and running into that thinking, wow, this is a shitty deal. All right. Okay, and to supplement that for Ryan there, yeah, Brady, the deed of trust, that's what's explaining what duties those trustees have. That's where, in that deed of trust, if you had some legislation suggesting something under the Trustee Act, well, now that you don't have possession of that security anymore, now you can actually literally use the legislation and the codes against our servants like we were supposed to be able to. That possession difference makes all of the difference. So anyway, yeah, that deed of trust is going to lay out a whole bunch of stuff. How many pages long is that thing? We're going to be probably in the 4-ish pages range, give or take.
Okay, so let's give a little bit more clarity on this, because even my wheels are spinning over here, because Darren's now going to talk about who's grantee and who's grantor in a different way.
Okay, so as I just suggested in the last segment there, when we were in possession of a certain something, proving we had it, which is why they ask us to identify as it, speak for it, live as it,
sign here
for it. When that happens, we just completed a grantee-grantor schedule right there. We showed up as grantees when we're 16 years old saying, look, I'm in possession of this thing. I'm of the legal ability
to sign up
and grant interests away. So at that very moment, when we don't express what it is we want in return, when you don't express your proper title, when you don't express your proper transaction, when you just literally walk up, give them a certificate, sign here, and walk away.
So pledged your allegiance to the game, and that's nothing in return.
All of that. We waived all of it. And because we waived it all, they can literally presume that it's gonna be like that for the rest of their life. Why? Because if they had any knowledge, they would have exercised it right now. And this circus is so freaking complex that there's no way a single man or woman could ever figure it out in their lifetime.
So this is where they kept the title. So when we talk about they give you back a security entitlement, what didn't they give us back then?
Okay, so 16 years old, you're showing up with the whole deal. You give them the good slice and you walk away with the bad slice. So now we were in the grantor position. We're literally stuck there. We granted something, call it the beneficial rights and interests, to the state. So the state is sitting there in the background as the beneficiary, enjoying the shit out of everything. We're stuck in grantor land, and no one knows what to do with grantee. This is where the registered mailing comes in. Why are we sending ourselves something in the mail? Here's why. If we're presumed to be the grantor, we can literally show up on a registered piece of mail And as long as we express the grantor as being in the all caps name, because that's who you are right now, you are deemed to be that fiction. You are the all caps name. You are the grantor. Okay, so as the grantor, so that's the all caps name there, if you want. Send something to the other capacity. So, all caps name could send the man or woman. Here's the interesting thing. You could literally still spin that. You can actually have the man or woman sending the all caps of something. Point is that you have to materially show on the face of this envelope the all caps name versus the name styled proper, or even the name styled in completely lowercase letters if you really want to take it to that level. So there's 3 distinctions, but 2 primarily. If that face of that instrument shows you got an all caps name and then you got a properly styled name over here, those are 2 capacities. That's you acting in your duality. That's you dually on the same face of the same document, whether it's an envelope, a document, an instrument, it doesn't matter. Now that there's evidence of 2 capacities on this envelope, that is evidence of something about to move, something about to be transferred, because the grantor presumably already has the thing. So now the grantor can use the mail system to send you something. This is why we're suggesting Stacy-grantee. When she goes to the mailbox and accepts that letter she sent herself, as long as she signs for it, Stacy-grantee, boom, that's enough evidence to prove to a judge, hey, you got your grantee spot back. Because you've expressed an interest in how to do it.
And only a man or woman would be able to know that there is a trick and that there's a difference, and they're trying to establish a difference.
No fiction, which is a piece of paper, can figure this out. Again, fictions are absent brain, they're absent thought, they're absent heart. You know, again, this is why the Tin Man's running around with no heart, and Lion's all scared, and Scarecrow, what was he doing? I forget. Anyway, we have to show, we have to itemize, we have to display our capacities. This is what the judges are really, really looking for, the evidentiary chain of title, or the evidentiary chain of command, is essentially what this is. This is you moving up the ranks. This is you showing the military commanders that you're not just an idiot out in the trenches, that you are worthy of being,
And I just feel so many questions coming in right now here, loved ones, and we will detail this a little bit more. But what you're saying here, Darren, is that you would be coming in your other capacity as the man or the woman, and you'd be sending the all caps name registered mail.
Yeah, as long as you can see the evidence of the 2 different distinctions in the title, in the capacities. That's fundamentally all that a judge needs to see for evidence. Oh, but look what else comes with this little transaction. Oh, now you get a little registered mail number that's attached to this very special event. As a matter of fact, loved ones, you can send yourself this envelope in the mail with nothing in the envelope. It can be empty.
Now, here's a question. With registered mail, though, you do have to present identification.
Yeah, well, we've already all got it. So you show up, here I am, as the all caps name, correct, clerk? Look, here's the all caps name sending, right, the properly styled name, and if the clerk says, no, that's the same, no, it's not. Most of our birth certificates have our surname listed first, correct? So then the sender could be you acting in person, because that's already deemed to be. So let's just pretend you're in person, costume stuck, for the rest of your life until you do something about it. Therefore, let's not argue that fact anymore, but go with it, roll with it, use it, direct it. Okay, so as the person, here's my all caps name on the upper left-hand corner of my envelope. The all caps name is going to send something to the man or woman. So when the man or woman receives that document at the post office, you sign for it as grantee. That is big-time proof that you know what you're doing with titles here.
And that's why, loved ones, when we spoke on the first recording about being the grantee, it's from that space we speak of, where you've established enough ground, where you have physical evidence to be able to show a judge the ability to be able to understand this and be able to convey property. Is that
Yeah,
correct?
okay, and we're gonna go right to red section here. We're gonna take this one layer up.
He's rolling up his sleeves. Get ready.
Okay, so this is where we need to prove that we have possession of something called the freehold estate.
A freehold estate. This is a new one for me.
Okay,
All right.
so the freehold estate has to exist first before we wrap a fee simple title absolute around it. The
So are
fee,
you establishing the inheritance then?
yeah, you basically have to suggest that, hey, there's a something over here. This exists, and now that it exists, now I can roll in and actually do something with it. But you see how you have to come and go. They want you to create the thing with clean hands, step out of there, then come back in as another character, modify it, step out of that character, then come back in as the third character, and then finally enjoy it.
This is why it's so tricky to navigate
Yeah,
this narrow path.
And again, because this is all military jurisdiction, everything is very compartmentalized. One lady sitting at this desk does not know what the lady sitting 6 feet across from her is doing. That's not her job. Did they talk about it over coffee? Probably. But anyway, that's how linear the military works. Okay, so we got freehold estates, we got fee simple absolutes, we got determinable interests, we got fees rolling around here, we got things to dive into and dissect and get a gallery built for these, because again, these are the very specific land title words. These are the specific words that the judges are really, really, really looking to hear. Again, A is vested in possession of a life estate. B is vested in interest. In trust for the benefit of C. Who is C? It's actually A. A shows up later to become C.
Hang on. That's just one big mind. You know what?
Okay, yeah, we'll just hit pause for there. We'll just wait. Okay, peace. Okay, loved ones. We got a really good question from X here. He suggests, as we need to transferee, or the solicitor thereof, to endorse the transfer instrument that must accompany the trust deed to enable issue of the indefeasible title, are we at best off-gauging the petition, first to surrender the finalize and disposition of the security interest? I'm going to suggest right there, yeah, what's going to happen here is even if the lawyer or solicitor does not want to get involved, does not want to touch your trust expression, he has to. As soon as you're the appointer and you privately appoint him or her to be the acting trustee, the express trustee, as soon as you express it, it's binding. The only way that that solicitor or transferee or appointee can get out of this situation is by disclaiming the trust. Now that's a loaded statement, because by the very act of disclaiming the trust, he actually claims it. He actually suggests or agrees that it exists and it's real. So here is a little bit of remedy, though, for those solicitors or lawyers. Yes, they can disclaim the trust, but because it's in open court, or even if it's in private court, it's on the table. It's verified. The judge can see it. The judge can smell it. And when it's there, all that solicitor can now do is ask the court to appoint a new trustee rather than the one standing there. But here's the thing, loved ones. Private administration of private express trusts is very lucrative. They make a lot of money, more than they do in their normal salary position as a lawyer, and I mean a lot more. So they had to make it advantageous for both parties. They can't make such an egregious situation that nobody wants to act as trustee. See, that wouldn't be beneficial to the entire system. So that is actually just sitting there waiting. So he goes on to say, and have the court, the honorable court, issue a vesting order so we can bring that to the registrar with the deed absolute at land titles, I think is where he's going, as a statement or a receipt. Yep. Okay, correct. Once the judge or the court sees that you have standing or you have that freehold title that you can now turn into a life estate, right? There's two little components right there going on. Yeah, first of all, you got to have possession, or you got to have an interest, or you got to that freehold estate must exist. Now, how do we evidence that estate? Well, that's what the birth certificate does. All we have to do is stipulate it or express it. That birth certificate evidences that freehold estate. So that solves a lot of our problems for us. And then, yes, the vesting order is very important. Vesting orders, again, is another equitable remedy where, hey, Your Honor, I'm no longer in possession of the legal character in which I was being sued. I'm bringing suit in my own name, and thereby I desire the court, or wish of the court, to approve my private vesting appointment, or approve my private appointment appointing new trustees, and thereby generate the vesting order. I can actually post a model vesting order that British Columbia has. It's kind of like a 2 or 3 page document right out of the courts. This isn't my wording. It's a model vesting order. So if you want to see some of the particular language that's used to move or vest these titles back and forth, I can post that a little bit later today. That'll be a simple one. He goes on to say, and for answers on the fly, he suggests here that he actually had the judge, or the master in Queensland, Brisbane specifically, grant him his leave and seal the case and this, that, and the other. But then the judge asks him, okay, so where's the land? Tough question. Okay, what is the land? Again, in this court environment, you can literally get away with saying this. Your Honor, the land is listed as collateral attached to an incorporeal hereditament. Incorporeal means spirit. It means an idea. I have an idea here, Your Honor. I believe, or I know, that I was vested of the trustee position, the debtorship position, and as surety, I'm stipulating. That word stipulate is very powerful. Use it as much as you can. So I'm stipulating herein, Your Honor, that the land is described and defined and listed as an incorporeal hereditament attached to collateral. Okay, what's the collateral? That is the birth certificate. Your Honor, further attached to valuable consideration and the subject matter of a trust deed expression, irrevocable in nature, even more specifically an inter vivos trust. Again, just string these things together. He's going to get a pretty good idea quick, and again, probably X if you check your definition of land, either in your Australian land titles paperwork or Personal Property Act or the Land Titles Act, things of this nature. You should be able to come up with a pretty beefy definition of the word land that encompasses everything, like we were suggesting the other night here on the show, where I dug up one from the Manitoba legislation that suggests, land is messuages, tenements, hereditaments, incorporeal, corporeal, of every kind and description, whether in equity or at law. So there you go. Again, that was just off the top of my head. I'm just trying to recall what it said. Something to this effect. Find a definition that matches something like that, and you'll be off to the races, my friend. Again, they just need clarification on a few facts to make sure that you know what the hell it is you're talking about, and that he can release the interests. He can vest the interests. He can do whatever it is he needs to do, but he needs to be confident that you're still not a lunatic who just watched a YouTube video or two, and you still actually don't know how to manage your affairs. So again, don't get discouraged. Don't get pissed off at the judges. They're only doing their job, because trust me, loved ones, at the end of the day, when the tables turn, wow, is it ever going to be worth it? So hang in there. Okay, I just wanted to touch base here quickly on where are the chancery courts. Well, wherever there's a legal court, there's technically a chancery court hiding in the background. Problem is if you go to the public counter and say, hey, clerk, where's the chancery court? What room is it in? Room 106? They're going to look at you like you are on crack. Why is that? Because the chancery courts don't exist on the public side, right? They're private. They're in the background. Why and where and how did this happen? Well, the Judicature Act 1873 to 1875. This particular piece of legislation out of England smashed chancery courts and common law courts together in the same room. But because the judges know and the system knows, all of us are running around in person, acting like we're something else. We have actually waived our right to the Chancery Court. We've literally cut ourselves off. We can't get to it. That's why we need to do something first to restore our position, our original position, to get into that Chancery Court. So, again, don't walk into these public courts and put yourself in a position where they think you're crazy. This is where it's very important that we establish things through affidavits and deeds of trust first. Get these deeds of trust filed at your local county recorder's office, or in Canada, for example, at the Land Titles Registry office. Once you have that output, for example, once you register this stuff, once you record this stuff, they will give you some output. They'll give you a piece of paper with a stamp on it, the clerk's initials. etc., 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 saying that this individual filed a deed of trust on this date. Take that now into court. Show the judge what you did. Show the judge how you've got some equities hiding here in the background that are not for the public. The public cannot see these things. That's what's going to get you into chambers immediately. The fact that you've established, and that's an important word, some of these key facts or some of these key subject matters, these subject material matters. These are the evidences that the judges are looking for. Without this stuff, we're literally just coming into court and by hearsay, acting like a lunatic and an idiot, making claims that all these equities exist, but yet we haven't quite done it properly. So this is where I'll talk about this in one of the upcoming episodes here, where the settlor may not have quite done this properly or effectually or 100%. Therefore, we actually require the court's assistance to help us finish all of this stuff. But as soon as we start expressing a deed of trust, again, this is where the grantee has that whole title, that complete title. They got all the legal and all the equitable. Once that happens in the grantee, now that grantee can put on the grantor hat or change capacities. And now we can come and grant or transfer or deliver that legal interest away. Now this is where the freehold estate comes in. We actually have to prove that the freehold estate exists first. Once that particular estate exists, we can prove it's attached or it's a part of the special instrument. What's the special instrument? The birth certificate. So now we prove that there's a estate that exists, and now we're going to come in and we're going to express some special interests regarding it, such as, let's say, indefeasible interests and defeasible interests, or contingent rights, things of this nature. Again, this all gets pretty sticky. This gets confusing, so I'm going to go over that in a lot more detail. But again, this little video was just to explain, hey, the chancery courts are there, but we must be entitled to get there first. Remember, all these public clerks are trained to deny you. Chancery doesn't exist. It hasn't existed for hundreds of years. Yeah, wrong. Because they assume you're a public citizen. That's why you're coming to the public counter, asking public crazy questions. That's why we get treated a little bit differently. So again, 1, 2, 3 here. Get that particular evidence in writing, in a deed of trust, expressed to a proper trustee. Set a KV, pour out oaths revis, all these things. We're going to get talking about all this stuff quick because there's a lot of meat and there's a lot of substance hiding back here, and it is literally pretty confusing to actually get your head wrapped around it. So we're going to do our best to decipher it and simplify it for everybody. That's to come. Thanks, everybody. Peace.